Capitol Connection from the Illinois State Capitol.
8 Republican-led states across the country have passed abortion bans, seeking to challenge, perhaps in court, Roe versus Wade and perhaps overturn the national precedent set in 1973, protecting a woman's right to seek an abortion. One of those states is Missouri. It borders here in Illinois. This conversation has supercharged the race for president in 2020, but it has also led Illinois legislators, Democrats who control both chambers, to push for stronger protections for abortion and seeking to cement Illinois' status as the abortion oasis in the Midwest. Some conservatives came to Springfield this week to push back against that effort.
If the RHA is passed, though, it makes abortion a fundamental right, and that would then repeal any other regulations on abortion. So abortion, it goes far beyond Roe v. Wade. Roe v. Wade imposes the legality of abortion on all the states. But what the Reproductive Health Act does is for Illinois, it would make abortion a, quote, fundamental right, similar to freedom of speech, for example. And so anything that infringes on that right then would be swept away. It has to be held to a high, strict scrutiny standard. So, for example, parental notice of abortion, that would be swept away with the Reproductive Health Act.
Joining us now is Representative Kelly Cassidy. What was your reaction to Alabama, now Missouri, 6 other states included across the country, passing various versions, some of them very similar in nature, that ban or restrict access to abortion and really push the limits on what has been described, even by the most conservative Supreme Court justices, as the law of the land in Roe versus Wade? They're now testing that. I guess, what was your reaction, and what are the battle lines that are being drawn here?
So it's been pretty clear for a couple of years now that there is a very concerted and strategic attack being laid out on reproductive rights, on women's rights. And that's why I believe it's so important for Illinois to respond with equal and opposite firmness in terms of our willingness to defend those rights through the Reproductive Health Act. When Alabama happened and these other states, you know, it was a gut punch, but a not unexpected one.
Can I ask a question I wouldn't normally ask?
Sure.
I notice your necklace.
Yeah. So this is, it's a wire hanger, and it is symbolic of what happened in the days before Roe v. Wade was passed, where women had to take matters into their own hands and frequently used wire hangers to induce abortion, and usually either became very, very ill or died as a result. This necklace was given to me by my coworkers at the Chicago office of the National Organization for Women way back in the early 90s when I worked there. And my mentor and first boss, Sue Purrington, was the person who gave it to me for my birthday when I worked there. And she's no longer with us, and so I wear it. I've been wearing it this session a lot to carry her and all of the folks who came before us with me as we take this battle on.
This discussion, this debate is always such a visceral one. It draws pretty hot passions, I think, from both sides.
It does.
Do you find that that's helpful? Are there ways or does that complicate the discussion? I think most people know where they stand on the issue, but how does that supercharged element make a bill like the Reproductive Health Act more difficult, or how does it affect that?
They can be harder conversations to have when on such polarizing issues, not unlike when we talk about gun rights or LGBTQ issues. You know, folks get dug in, and it can be hard to talk with each other instead of at each other.
Pro-choice versus pro-life has a long history in Illinois, especially at the state level. And I think maybe some people are aware of this, others may not be. What is that history in your view? What's unique about it, and what are you looking to address in this RHA, the Reproductive Health Act? So
at the beginning of my career, I mentioned my necklace when I was with NOW. There was a time that we weren't a pro-choice majority in my chamber or in the Senate, and lots of restrictive bills were passed, both when we were when the Democrats were in the minority and sometimes when the Democrats were in the majority.
What are some examples of those?
So there's spousal notification or spousal consent, waiting periods, restrictions on facilities that are onerous and unnecessary, criminal penalties for physicians who perform abortion, hospital panels to get consent from, misinformed consent where a doctor has to be given a script to read to a patient before performing an abortion. All sorts of things that are really just meant to chill that right, to make it harder for a person to access abortion services or reproductive health care services. And so these items are still on our books, because when you go into court and have something overthrown or get a ruling that something's unconstitutional, there's an injunction placed. It's as if it's got a brick on it. It can't be enforced. But those items remain on the books. And I think a lot of people believe that when you win in court, the language is magically deleted. And that's not the case. And when the legal precedent that is the foundation for that injunction goes away, the injunction can go away as well. And so those laws, that brick, if you will, gets lifted, and those laws can then be enforced.
One of the opponents who was here lobbying this bill, against this bill this week, took issue with, I think, something you might have mentioned there, which was the number of doctors present. She was making the case that a woman is more safe when there are 2 doctors there, and that reducing that puts the woman at greater risk.
That's, again, not true. I mean, we actually only require a single doctor to perform a cesarean section, which is far more invasive. And so it really just aligns with that. Nothing prevents someone from assisting or having multiple doctors present. But, you know, again, using science to make these determinations is really what we're trying to do here.
When does life begin?
I think that depends on your tradition, but that's not the issue here. The issue is, do I have agency over my body? Am I in control of my destiny? That's my question.
So how does the RHA affect, is there a timeline in the bill of how late into a pregnancy that could be terminated? What
we've done in the bill is put that in the hands of doctors who can make a determination, because there's not an arbitrary number for when viability exists. And so using accepted standards of clinical practice, like we do with all other healthcare procedural decisions, gives that opportunity to say, for a doctor to say what is and isn't happening with that patient at that time.
I think in New York we saw the law change from protecting the life of the mother to the health of the mother. Do you address that in your bill at all? Or?
I mean, that's always, again, back to those questions of doctor decision-making. Physician and patient relationships are what's important there.
That, does this bill have language that specifically adjusts that part of the law?
I don't know if that's in there or not.
Okay.
I'm not sure exactly where you're pointing to, so without it in front of me.
Sure, I'm asking about, does your bill change it from the life of the mother to the health of the mother? You mentioned the doctor's input there. What are some examples, I guess, of...
well, you were specifically asking about viability.
Right.
You weren't talking about that question. I think that there's a standard, the standard set by Roe is about life and health. And so putting that in place in the event Roe goes away, I think might be what you're discussing. But the question of viability isn't one you can put a number on. That's my point.
I see.
People are asking, is it this week or that week or the other week? It depends on what's happening in that particular patient at that particular time.
Representative Kelly Cassidy, thank you for joining us. We're back in just a moment.